Is the case you are filing a slam dunk? Individuals who consider obtaining lawsuit loans must analyze elements of their cases very carefully. Although most litigants consider their cases relatively straightforward, this is seldom the case. Before launching into the lawsuit, it must be borne in mind that there are two sides to every story. Key to obtaining an objective view of a particular lawsuit is a competent attorney. It is always difficult to look at your own case in an unbiased manner. It is quite natural to make the opposing party appear worse than that party truly is. Now, it may be true that the other party does have a malevolent intent. However, in most cases involving litigation, the parties maintain what, in their own minds, are justifiable positions. Therefore, the impasse must be resolved before an impartial arbiter. The vast majority of cases in the United States will be settled by either a judge or a jury, assuming the case is not settled prior to trial. Our judicial system ostensibly provides the means by which parties may engage in litigation on relatively equal footing. Many individuals justifiably challenge this portrayal. It is often seen as though the system tilts strongly in favor of those with wealth and financial means. The cost of litigation appears to be steadily increasing. Our judicial system also permits us to attempt to resolve most matters in a civil forum. Once again, this statement has numerous detractors. There is a tremendous benefit to obtaining settlement loans to assist with the mounting financial burden that is correlative to litigation. Furthermore, lawsuit funding is often beneficial to the attorneys who represent plaintiffs, allowing the attorneys to continue to pursue litigation when litigation funding would have otherwise been scarce to non-existent. Although many attorneys/agencies will provide pro bono services, in most instances, the services one obtains while pursuing a lawsuit are not free. In fact, these services are quite often both burdensome and costly. Of course, if your case truly is a slam dunk, the cost of litigation is likely to be more easily managed. If it weren't for the fact that plaintiffs often find themselves confronted by overwhelming expenses/costs, settlement loans would not be a popular form of assistance. Individuals contemplating lawsuit loans need no reminders regarding expenses. There can be no doubt that individuals involved in litigation often feel as though the costs involved are unceasing. In fact, it is often bewildering to be confronted by costs/expenses that appear to come out of left field. In addition to your own expenses, as well as those things that you can anticipate/control, at least to some extent, the defendant is going to be mounting/developing the case in opposition. Although you may feel as though your case is a slam dunk, the defendant is likely to have a contrary view of the case. In the vast